This week on Rochelle's Daily Wire video edition, we're going to give you a rundown on the 3 bankruptcy cases that are currently pending in the Supreme Court. First, we have In re Fulton, which could be, when it comes down, one of the most important bankruptcy decisions in 3 years. The Seventh Circuit held that when someone files a Chapter 13 petition, a creditor who has repossessed property before bankruptcy is compelled by the automatic stay to return the property to the debtor. The Supreme Court granted certiorari last year to resolve a split of circuits. The case was intended to be, or shall we say, scheduled to be argued on April 20th, but as you know, the Supreme Court suspended holding oral arguments last month on account of the virus pandemic. The Supreme Court has just this week ruled that several cases will be argued this spring by video hookup, but I guess the Supreme Court does not consider that the bankruptcy case is sufficiently important. So the Supreme Court this week has adjourned oral argument in the Fulton case until the term to begin in October of this year. That means, as a practical matter, I think that we will not have a decision from the Supreme Court until early 2021. Second, we have the Madoff case. You'll remember Madoff. That was the world's largest all-time Ponzi scheme where investors lost some $17 billion. The Second Circuit held that neither the notion of comity or the presumption of against extraterritorial application of statutes does not apply when a bankruptcy trustee sues a subsequent recipient abroad for a fraudulent transfer. In this particular case, Madoff had made transfers from the U.S. to offshore feeder funds in places like the Cayman Islands. The Caymans, in turn, sent that money to their own investors who were also abroad. The Second Circuit reversed the district court, which had dismissed those cases, and the Supreme Court last year asked the Solicitor General for his opinion on the case. Well, about a week ago, the Solicitor General filed his brief and said, number one, the Second Circuit was correct. Number two, there is no split of circuits. And number three, the Solicitor General recommended that the Supreme Court deny certiorari. We should have an answer from the Supreme Court about denying certiorari, which I think will be the result, probably in late May. Third, we have the Puerto Rico case that was argued in the Supreme Court in the middle of October, but as yet we do not have a decision, even though the court has made its decisions in almost all of the other cases argued around that time. That was the case, if you recall, where the First Circuit held that the Oversight Board in Puerto Rico's debt workout under the unique PROMESA law was unconstitutionally appointed because the members of the board were not nominated by the president and confirmed by the Senate. I'm suspecting that we don't have a decision yet because I'm guessing that the decision is going to be written by Chief Justice. And as you recall, the Chief Justice spent a lot of time earlier this year presiding over the impeachment, and that might explain why it is taking a long time to get a decision in that case. Also, I'm beginning to suspect, because it's taking so long, that there will be multiple dissents. Well, that's what we have this week on Rochelle's Daily Wire video edition. We will return next week to tell you about something that you need to know about in bankruptcy law. Until then, stay home, be well, and take care of yourself and your family. Good day.